reiterate what the previous speaker said in relation to the copy of the speech, Minister. It's very handy to have it, and I looked for it. And I accept that. But it slips in gradually with different ministers where we don't get the speech, and it's very useful. And just in relation to this, I want to focus in on the sprat, and I want to use my time here, as I have repeatedly since I came here, really. After 18 in relation to this matter. And so the government came up with a policy, to my unexpert eye, which I thought was excellent, and I praised the government for it. And it was in relation to bringing in a policy that would ban the bigger trawlers over 80 metres from the baseline out 6 miles. And there were many, many reasons for that were set out, in terms of the damage being done to the ecology by the overfishing, and also then the importance for the local fishermen and local industry, and a huge spin-off effect. And I couldn't have praised the government more in relation to that. And there was a lead-in time for the big boys, as I just called them, to get out. And then what happened was the policy, when it was brought in, was challenged. And over the last number of years, the same speech has been given. And I apologise to you, Minister, I know you're new, and it was only at the end of your speech about the legal challenges and that. But I'm going to come to those legal challenges now, but in relation to those, there was still flexibility for the government to act, and certainly within the baseline area, to make sure the big trawlers weren't in there. But in terms of the challenge that was taken, so it was taken to the High Court and then to the Court of Appeal. On both occasions, actually, the plaintiffs failed. Just let me make this clear. They failed in what they were putting before the court. On every single level, they failed. The High Court, however, found that the consultation process was faulty. On that one issue alone, the High Court had to hold the policy as null and void. But it's worth repeating, and it's worth reading the High Court case and the Court of Appeal that set out clearly that the government was perfectly entitled to bring in a policy. And it set out the nature of that policy. And it didn't endorse the policy, but it went as far as it could to endorse the policy in saying we cannot interfere with a government that brings in a policy ostensibly for all the right reasons, but unfortunately in relation to this one aspect, the consultation part locally was faulty. That then was appealed by both sides to the Court of Appeal, which was finally heard on the 10th of March 23. Remember now, we've gone from 18 up to the 10th of March 23, and during that time, detrimental consequences in relation to the overfishing of sprat. And this is not just about sprat, this is about the consequences of the overfishing of sprat for ecology and for the whole rhythm of life in the water that you spoke so eloquently about earlier on, and the Taoiseach did lately at a conference. And so, every September, I and other colleagues are inundated with calls telling us that the big trawlers are in the water fishing unsustainably. And indeed, the catchment of sprat has gone up. I have all the figures there. I'm not going to read them out. They're on the record. Okay, so that's what's happened in the meantime. So let's look then at the 10th of March 23, and the Court of Appeal issued its decision striking down the policy directive. And now, why did it strike it down? It struck it down this time because of the government's failure to notify the EU and the UK prior to the introduction of the directive, rendered the directive invalid. So the government and the department, or whoever the responsible person was, made a mistake, failed to notify the EU and the UK in whatever procedure was required. They didn't do that, and this policy was held as null and void. However, the court, and this is what's important, the court did not hold with any of the arguments of the plaintiffs in relation to the actual policy directive. The court concluded that the directive was a measure for the conservation and management of fish stocks within the meaning of the relevant articles. And then, importantly, the policy was not discriminatory, had not been shown to be irrational, and that it did not involve a disproportionate interference with the applicant's constitutional rights, the plaintiffs that took it, the owners of the bigger boats, 2 or 3. So it wasn't irrational, it wasn't disproportionate, it wasn't discriminatory. Can you imagine? We have the Court of Appeal, almost the highest court in the land, telling us that the application brought, based on arguments, none of them were found to be valid, if I put it in my own words, and yet the policy was held at naught because of the failure of the department and the government to notify. Now, I'm not here to highlight mistakes. What I'm here to highlight is the consequence of that mistake, and not just the mistake, because there was flexibility for the government to act and to have not acted. And so that's March 23. It's now over 2 years and 3 months since that, and we still have no policy. And I'm now looking at my third minister, senior minister or junior minister, in relation to this. And I have to absolutely deplore the lack of action and the constant mantra repetition that the courts held this up. Everybody is entitled to go to court, and certainly I'm not going to criticise anyone that takes a case. Obviously, it would be better if the court system was more efficient. Obviously, there weren't enough judges and so on. So on a different level, that has been rectified to a certain extent. But it's inexplicable that we're now 2 years, 3 months later, we still have no policy. And you're telling us positively something will be done, hopefully by September, I think. But I don't hear the words that a new policy has been put together and that policy will now be launched. A date for that. I don't hear anything like that being said. And the last time around in the consultation, and again, there wasn't even a need for a consultation, actually, but the department did the right thing. They clearly went out and consulted. And what the court said, when you go out and consult, there is a duty to do it properly. So there was a nuanced difference between the High Court and the Court of Appeal. One was saying that the consultation locally and nationally hadn't been done, but the ultimate decision was we didn't tell the EU and the UK. So what has happened in 2 years, 3 months? I don't. Where is the policy? Can you give us just tell us today when that policy? What has happened in the meantime? Every time I've raised it, which is frequently, I'm told, there were 5,500, I think, the applications or comments on it put in, as opposed to about 900 the last time. And I realise the amount of work that takes, but it doesn't take 2.5 years, given that no court ever held against the policy. That's exactly what we need to do, is conserve, and the courts back that up. How could it take that length of time? I was down in Bantry lately. I certainly wasn't in great humour going down to Bantry because it took quite a long time to drive down there. But I was in a public meeting that was absolutely well attended. It was packed. I would have thought 500, but maybe not. The room was a bit smaller than that. It was well attended. An absolute goodwill to do something for the environment, for the ecosystem. None of it, not in my back garden, none of it. Ample time for those that didn't agree, which was a small few who had vested interests, and they're perfectly entitled to speak, and they spoke. And the concerns on every level, not just in relation to Sprat, was just palpable. Now, Minister, I've used my time there's many more things I'd like to say about local fishing, but I've used my time specifically because I've never had that many minutes to discuss this one particular issue, to get some truth out in relation to it. So my final 8 seconds, I'm asking, when will the policy be published? Where are we at precisely in relation to the policy? Have we finished examining all the hIascach that went in? And when will we have the policy?